court's questions.
If a third party brought a 1983 action challenging this ordinance and won prospective relief, what would be the effect on the reasoning underlying the enforcement of the ordinance against petitioner?
We think that it would imply that the ordinance was invalid in the same way that this prospective suit if brought by petitioner would imply that his conviction under that past statute was invalid. That's why we don't understand this court's necessarily implies test to extend to prospective suits brought by individuals outside of custody. Where we do understand the necessarily implies test to apply are two circumstances. The first is where an individual is bringing a retrospective suit or a suit for damages. In that context, the context of Heck, this court has considered claims that would imply the invalidity of a conviction to be analogous to malicious prosecution and held that they're barred. In addition, when an individual is in custody, this court has held that any relief that would necessarily imply the invalidity of a conviction is barred. And we would understand that to include prospective suits. Ordinarily, of course, as this court said in Edwards, prospective suits won't imply the invalidity of the individual's conviction and therefore his confinement. But where they do, and we think a prospective facial challenge would necessarily imply a legal infirmity in the conviction, we would understand those suits to be barred too. But when an individual is out of custody and bringing that type of prospective suit, that's just woolly, and the court has made clear that those claims can go forward.
What if a non-prisoner seeks to compel testimony in a collateral attack on his conviction, like a proceeding for a writ of error coram nobis?
So if a non-prisoner is bringing a sort of backwards-looking attack on his conviction, we think that's barred by the even more basic principle that federal courts don't sit in review of state court judgments absent express authority. The habeas statute, of course, is one such express authority, but it comes with a host of procedural limitations that Section 1983 does not. So Section 1983, of course, can't be used as a vehicle to try to invalidate a past conviction or its effects, whether a person is in or out of custody, but Section 1983 can be a vehicle for prospectively challenging a law to avoid future prosecution and the future effects of that law.
I'm finding your argument very confusing, and so maybe you can help me. I mean, Justice Sotomayor had a very kind of simpler way of thinking about it. To the extent the person is bringing a 1983 lawsuit that includes an element that would be shared or the element that involves the past conviction, you can't do it. If he's not doing that, then you can. So how does that differ from the formulation that you are proposing?
So I think our line is similar with one caveat. So we generally agree with that bright line between retrospective attacks and prospective attacks. The caveat is that for individuals in custody, we think the court has imposed additional limits to avoid a conflict with the federal habeas statute. So if someone is in custody, we understand the language in this court's opinions to suggest that they couldn't bring even a prospective suit that would necessarily imply the invalidity of their conviction, and a facial challenge to their statute of conviction would be that type of suit.
So